Usually we have our ever faithful sergeants at arms, Joe Crook, Warren Hawkins, Dean Marshburn, and Thomas Terry. We have some pages today representing various parts of the state. We have, if you'll just stand up and wave when I call your name, Brooke Hardister. Brooke, sponsored by Speaker Moore. Hayden Hicks. Welcome, Hayden. Representative Sarah Stevens. Addison Reich, okay. Representative Dennis Rodell. Bruno Rivas. Representative Ashton Wheeler Clemens. And Harper Smith. Speaker Tim Moore. Welcome. I hope you're enjoying your week so far. It's just Tuesday, so you've got a lot of voting sessions, a lot of committees to be in this week. We have another committee going on, so we got a lightly attended today. We got the Education Committee is meeting at the same time. And our agenda, we have one bill. Where's my agenda? We have one bill before us, and it's the PCS. I need a motion to have the PCS properly before us. It's been moved, and it doesn't require a second. So without objection, the PCS is before us. Representative Davis, and we're going to be at ease just a minute. I need to pass the gavel to Chairman Gillespie before I help present the PCS. So we'll be at ease for 2 minutes. Chairman Gillespie represents the Far West, but he's usually on time anyway. Representative Goodwin and Kidwell, we are at ease at the moment, waiting for Chairman Gillespie. Representative Daly, we're waiting for Chairman Gillespie. We're at ease right now. Chairman Gillespie is just in time. Okay, we're back in session, and I'm passing, we've already approved the PCS to be considered. I'm passing the gavel to you, so I can help Representative Davis present our bill. And
I guess my timing is impeccable. Just at the right moment. Senator Davis.
Don't give me a demotion.
Sorry, I didn't know where you was at. I just got in the room. Present the bill, sir, or the PCF.
Thank you, Mr. Chairman. Members of the committee, the comments that I'll be making, I'd like for you, will be pursuant to the summary that all of y'all received last evening, and also the bill, which you received a copy of the PCS last evening. If you look at the summary, it gives you a little background. And I want to thank Jennifer McGinnis for helping to put this together, because I thought it was important for people to understand a little bit of what's happened in the past and why we're here now. As you can see, it gives a little background about PFAS. It gives a little background about maximum contamination levels. It also gives some background about liability for PFAS contamination in private wells. And it also gives some background about the current authority of the Secretary for DEQ to require abatement of nuisances impacting public water supplies. But what I really want to direct my attention on in the time that we have is, what does this PCS do? As members may be very well aware, I introduced legislation one session ago that addressed this problem, and it was late in the session before it recessed. It was not able to go for hearing towards the Environment Committee. So when we came back this time, Representative Eiler and I got together and reintroduced House Bill 864, which changed several of the things that were in the original bill that had previously been introduced. And this PCS even changes what was originally filed in House Bill 864 in an attempt to try to address concerns that I heard from different individuals. And so, if you will, I'd like to address what does the bill do? Section 1 would authorize the Secretary of DEQ to order a responsible party to pay a public water system any actual and necessary cost incurred by that public water system to remove, correct, or abate any adverse effects upon the water supply resulting from PFAS contamination exceeding a permissible concentration limit for which the party is responsible. And such costs would include the cost to procure, implement, maintain, and operate technology to reduce PFAS contamination in finished drinking water below the permissible concentration level. In looking at the bill itself, if you look at Part 1, Paren A, in print, and then look at subsections 1, 2, and 3, trying to define the different languages in the bill so that hopefully everyone can understand what this bill does and what this bill would affect. When you talk about permissible concentration level, when this was, I originally did this, it was going to be DEQ that would decide the contamination level. That is no longer the case. As you know, the United States Environmental Protection Agency has come forth with maximum contaminate levels, MCL, that address not only, that do address the different levels that different contaminants that they have addressed would be in question, and also combined chemicals. So in other words, this leaves solely in the discretion of the Federal Environmental Protection Agency to come forth with the contamination levels that will be used. In looking at a PFAS manufacturer, there's been a lot of misinformation given about what is a manufacturer. So I've tried very hard, as Representative Eiler has as well, and with staff, to put in here in a definition of what is a manufacturer. Manufacturer is a person, and the reason we use the word person is because that's consistent with other bills that deal with environmental issues. As a matter of fact, a person is defined in GS 130A-313 as an individual, corporation, company, association, partnership, unit of local government, state agency, federal agency, or other legal entity. And that's why that term is used in this bill. It's all encompassing. A manufacturer is a person that produces PFAS compounds through processes including but not limited to electrochemical fluorination, telomerization, fluorocarbon polymerization, and production of fluoropolymers. And this is very, very important, and I hope everyone from the business community listens to what I'm about to say, because the definition specifically states that this term shall not include PFAS customers of PFAS manufacturers that use raw PFAS feedstock, for example, to produce commercial or consumer goods such as weatherproof caulking, or as intermediary products for use in the manufacturing of commercial goods, such as a grease-proof coating for a pizza box. What that means is, if I am someone who's making PFAS from scratch, I'm a manufacturer. And let's say each one of you owns a business and you make a particular product and you purchase as part of what you need to make that product something that has PFAS in it. You would not be a manufacturer. This bill would not affect you because you didn't make it from scratch. You may have used something that had PFAS in it, but you did not make it from scratch. So you don't even qualify as being a manufacturer. A responsible party. This is a PFAS manufacturer whose discharge or release of the PFAS into the environment has caused or contributed to the presence of PFAS in a public water system. Meaning you can manufacture from scratch PFAS, but as long as it didn't get into the environment and then get into a public water system or utility, you're not subject to the bill. It also states in here that the Secretary, meaning the Secretary of DEQ, may order a responsible party to pay a public water system, not the ratepayers that are on the hook for this, but the public water system, any actual and necessary cost incurred by that public water system to remove, correct, or abate any adverse effects upon the water supply resulting from contamination for which the person is responsible if the Secretary determines all of the following. There are three things that the Secretary of DEQ would have to look at in order to make a determination. Number one, that that person is a PFAS manufacturer, that they're making it from scratch, that the PFAS manufacturer discharged or released the PFAS into the environment that caused or contributed to the presence of the PFAS in a public water system. And the next thing would be that the concentration of PFAS in the public water system has exceeded a permissible concentrated level. Once again, that being established by the United States Equal Protection Agency. Also, as far as the bill, Section 2, and let me state that originally in the first legislation that was introduced sessions ago, it stated in there that if the Secretary did bring an action against a responsible party, that it would be calendared within 60 days in Superior Court. That has been eliminated. That is not in this bill. While the Secretary may be able to bring an action in Superior Court if the responsible party does not agree to remedy the situation, there is no time limit on when that has to be heard. It also includes the bill that a public water system receiving funds from a responsible party must reimburse taxpayers. Because remember, the people right now that are on the hook for this contamination that goes into these public water systems, such as Cape Fear Public Utility and such as the utility in Brunswick County, their rates have to go up to pay for the equipment. And you're talking about millions upon millions upon millions of dollars to get the equipment to put in these utilities so that you can have clean water drinking or clean drinking water once it comes out of that utility. And it's not fair for the ratepayers to have to pay this bill while the people who are actually responsible for making this stuff from scratch that got into those utilities are having to foot the bill. That's not right, and it's not fair. So if a public water system does receive funds as a result of whatever action that has been taken against them, then they must reimburse ratepayers of the system through a reduction in future rates charged. If, number one, the public water system had previously expended funds to remove, correct, or abate any adverse effects upon its water supply resulting from PFAS concentration, and the amount of funds expended by that water system for that purpose has been included in the rates charged to the taxpayers. Which simply means if the taxpayers or the users, ratepayers, have had to pay out money for this equipment, and a responsible party is found liable as being a manufacturer and responsible for this stuff being there, any money that is received as a result of that will go back to the ratepayers. That is fair. That is fair. In closing, the Section 2 of the bill would appropriate $300,000 in non-recurring funds during the 2024-2025 fiscal year from the general fund in order for DEQ to implement the requirements of this legislation if it has to do that. It also would require DEQ to report to the Joint Legislative Oversight Committee on Agricultural and Natural and Economic Resources no later than December the 15th, 2024, and annual thereafter on their use of any funds that were appropriated by this act, including abatement orders used by the Secretary. Like I said, there's been a lot of talk about this bill being anti-business. Since I've been in the State House, my voting record documents that I am very, very pro-business. In fact, I've been recognized by the North Carolina Chamber of Commerce as a jobs champion every year that this recognition has been given by the Chamber. I've also received pro-business recognition from the North Carolina Free Enterprise Foundation multiple times. This legislation is not anti-business. This legislation is about protecting us to have clean drinking water and also to protect the ratepayers for the utilities, not to have to foot the bill for the humongous expense to buy all this equipment to make the water be able to be safe to drink. I'll close by saying if this legislation, once again, is not anti-business, because if it was, I would not have filed it and I would not be here before you. Thank you, and I ask the committee to please vote for a favorable report to allow this bill to move forward. Thank you.
Thank you, Representative Davis. I believe that Representative Ireland would like to speak to the bill before, then we'll open it up to committee members.
Thank you, Mr. Chairman. And thank you, Representative Davis, for putting forth this bill, and I was happy to get on board. We've had a big, since 2017, we've had a big uproar about Gen X and all the other PFAS chemicals down at the lower end of the Cape Fear River. And matter of fact, let me do a couple of things from a personal privilege. We have a Brunswick County Commissioner with us today, Frank Williams, over here. And I know that we have a representative in a few minutes may get to speak from Cape Fear Public Utilities, and also a director, and also Brunswick County Director of Public Utilities. So I summarized the bill this way. I don't know if I came up with this or somebody else did. It's 3 strikes and you're out. First, you got to manufacture, not just use, but manufacture. I mean, McDonald's boxes are not PFAS manufacturers. You got to manufacture. You got to get into a public water supply. And it's got to into a public utility. 1, 2, 3. 3 strikes. If you don't do all that, then you're fine. You get the base on balls. So that's my summary of what you just heard from Representative Davis, and recommend a bill to you.
Thank you, Representative Eiler. I welcome up for any committee that would like to ask questions or comment. I am so surprised to see Representative Harrison raise her hand. You're recognized.
Thank you, Mr. Gillespie, and Representative Gillespie, Mr. Chair. This is a very happy day for me. So these are all friendly questions, I hope, and it's a series. Should I go back and forth, or maybe I'd be recognized for a series?
Yes, ma'am.
So thank you, and I really want to commend Representative Davis and Eiler and Miller for moving this bill forward. We all know what a big problem PFAS is in our state. The recent news that we have 2.5 million North Carolinians are drinking contaminated water, and the health impacts include immune suppression, all kinds of cancers, developmental disabilities, limiting vaccine responses. So I'm glad. I realize this doesn't deal with the issue, but the polluter pay piece. But I want to thank you for addressing at least that part of it. So I wanted to start with this. I don't know if it's for you or for staff. So the EPA has been sued by the ACC and the National Associated Manufacturers they've sued these new MCLs, and so what guides us? One, if that lawsuit is still pending, or if the federal court challenges or stays the EPA's ability to. And can I add another part to this too? Just so you can answer it all at once. There are more than 5 chemicals in the PFAS family. That's all the EPA. I think it's 5 or 6 of the EPA. They're 15,000. So I'm just wondering about cleaning up the ones that aren't identified by the EPA too.
Representative Harrison, yes, suit was just filed, I think, a few days ago. So obviously the court hasn't taken any action yet. It's very early in the game, so those MCLs would stand at this point. Now, of course, there is the possibility that the regulations could get stayed, but I don't believe in the case of a stay. I think it would still be operational. And Representative Davis' bill, obviously, if the regulations are invalidated through the courts, then we would have to look at tweaking the definition of permissible limit, because the MCLs would no longer exist. On your second question, that's right. They established MCLs for 5 PFAS and then for a combination of PFAS. So there are many, many compounds left to deal with, but this is right now just triggered to those with MCLs established by US EPA. So it would just be, of course, Gen X is one of the 5 that US EPA established an MCL for. So one could argue that's pretty relevant.
No, I appreciate this, and these are not meant to be antagonistic. These are friendly. I'm just trying to figure out the implications, because I kind of anticipate how these things are going to go in the federal court, and I don't know if they're going to uphold it. So I just wondered what, and I know that we've also got the EMC working on this, but they seem to be quite delayed. Doesn't matter though, because even if the EMC adopts their own MCLs, they wouldn't. It wouldn't matter. It wouldn't apply here.
Thank you, Mr. Chairman. That's right. It's no longer tied to anything, any limit established by the state. So it doesn't matter what the EMC does or does not do for purposes of this legislation.
Okay, follow up. So it's only water. It's not air, contamination from air. There is evidence of air contamination. But if this is only applying to one company and that company is operating under consent order, then maybe it doesn't matter?
Mr. Chairman, so I believe that the discharge can happen by air deposition. Mm-hmm. So my reading of the language PFAS manufacturer discharge or release PFAS into the environment
Okay.
that has resulted in caused or contributed presence of PFAS in public water supplies. So my personal legal opinion is that would include air deposition.
Thank you, and I think this might be my last because I know there are people that came here to speak. So the responsible party. I appreciate the PFAS manufacturer definition. I appreciate the clarity there. It's troubling to think that people could still apply PFAS to the insides of pizza boxes because y'all that stuff gets right into our system. But I get that point. We're trying to get at the potential, but I hope at some point we'll think further down the road. If somebody intentionally uses a toxic substance, maybe there ought to be some liability, and maybe there is existing liability when somebody intentionally uses a toxic substance in the manufacturing process. Do we have anything covered in our statutes?
So, I mean, theoretically, I think there's nothing that I can think of. Perhaps the department has thought through this issue, but if you're talking about someone disposing of tons of pizza boxes that are covered in PFAS, I don't know that there's liability under environmental law for that. If they took a whole truckload of pizza boxes and dumped them in a surface water, that you could probably get to some liability from that. Of course, you're not allowed to cause or contribute to water quality violations, in water bodies, surface water, no matter how that comes about. So, but that's, I think, what it would take to get to liability for just having PFAS products.
Okay, I promise this is last. I thought it was, but so I'm thinking more fire foam. So that fire foam incorporates PFAS chemicals, PFOS or whatever, and that's what's contaminating half the state or whatever. And that's not going to be covered at all by this. No liability attached to the manufacturer of the PFAS substance that goes in the fire foam that's contaminating water all over the state. Is that right?
So the manufacturer of the PFAS, yes, but the firefighting foam manufacturer, if they're just taking PFAS feedstock from a PFAS manufacturer, that firefighting foam manufacturer would not have liability under this bill.
Thank you. And I'm very strongly in favor of the bill. I'm not going to make the motion in favor, so we'll have a better chance of passing. But I am very strongly in favor of the bill. Thank you.
Thank you for that wonderful series of questions, Representative Harrison. Do you care to comment on any of Representative Harrison's questions?
None other than Representative Harrison. Remember, for someone to be affected by this particular bill, once again, they'd have to make it from scratch. It would have to be released in the environment, and then that would have to go into a public water supply. But for all of those things, and once it got into the water supply, it was not above what the Environmental Protection Agency has established as permissible levels. Short of all those things, you won't be subject to the bill.
Thank you. Any other committee members? Representative Wheatley.
Thank you, Mr. Chairman. I would like to hear the speakers first, if possible, and then make a comment about Cumberland County.
Yes, ma'am. Any other committee members? Representative Pickett.
Thank you, Mr. Chairman. Question for the bill sponsor. The enforcement of this, is it going to be strictly with the Secretary of DEQ, or are they going to have a commission doing it, or be solely with him?
What the bill, and thank you for the question, what the bill says is that if the Secretary, in using those criteria that are set out in the bill, is of the opinion that someone is a responsible party, a manufacturer responsible party, and obviously that person is given notice of this and the opportunity to correct. If they do not do that, then an action can be brought in Superior Court. And I took out the part about it having to be counted within 60 days, because I didn't really think that was fair. I thought it, plus I'm not going to tell a judge who's in control of his docket when something has to be heard. But it will allow all the parties ample opportunity to go through discovery, whatever needs to be done before the matter would actually be heard in Superior Court.
Any other questions from committee members? Representative Alter, you stepped out. I didn't want to cut you out. Do you have any questions? Okay. At this point, we will open up. Whoop. I'm sorry, Representative Dixon. I don't know how I overlooked you. I apologize. You have the floor, sir.
Just for a brief statement, I think it's important for us to understand that Chemours has been permitted to do what they're doing with the state of North Carolina knowing some of the things that occurred in West Virginia, maybe other places. They issued a permit to Chemours. And I think that the state has some responsibility here. Going back to the permitting process. So the state of North Carolina, DEQ specifically, I think it was Diener at that time. In my opinion, they dropped the ball.
Representative Davis.
Representative Dixon, I appreciate your comments, but I would say that even though whatever may have been going on in the past went on, they knew what they were doing, putting that PFAS in the water. But it was not discovered until 2017. And it's only, all of this has come about since 2017 because that's the first that we really knew that it was actually in our drinking water. But I appreciate your comments.
Any other comments from committee members? Hearing none, we'll move to those that have signed up. I'll call your name. If you would come forth to the speaker, you'll be given a microphone, 2 minutes, 1 minute, then the next one's 2 minutes, and then that's it, 2 minutes. So when you come up, please announce your name and who you're with. Beth Eckhart.
Okay. Thank you. I'm Beth Eckert with Cape Fear Public Utility Authority. I'm the Deputy Executive Director in charge of Environmental Management and Sustainability there. I want to thank you for having us. So on behalf of the Cape Fear Public Utility Authority and our approximately 200,000 customers that reside in the city of Wilmington and New Hanover County, I would like to thank the committee for allowing me to speak about our PFAS experience. An experience that began almost 40 years ago without our knowledge and that continues today. Several years ago, thanks to North Carolina researchers, we became aware of the PFAS chemicals that our neighbors upstream have been pouring into the Cape Fear River, our drinking water source, since the early 1980s. These chemicals could not be removed by our already advanced tertiary water treatment processes. The people of southeastern North Carolina, our customers, deserve clean, safe drinking water. So at that time, CFPUA began planning for treatment of PFAS. Over the last 7 years, we conducted pilot studies, we completed design and construction, we made interim treatment changes, and we are now operating and maintaining a granular activated carbon filtration system to treat PFAS coming down the river from our neighbors upstream. This treatment has come at a cost of $54 million with an estimated ongoing cost of approximately $5 million of periodic change outs of the carbon to maintain functionality of the system each year. To date, CFPUA has incurred nearly $75 million in PFAS-related expenses. All these millions of dollars are coming from the rates CFPUA customers pay. Not from those who are financially benefiting from the manufacture and sale of these PFAS chemicals. Our community of hardworking North Carolina families has spent and continues to spend millions to treat pollution we did not cause but cannot ignore. We believe these costs should be borne by the polluter, not the North Carolina residents who are burdened by the pollution.
Thank you. John Nichols.
Utilities Director for Brunswick County, and I want to thank the committee members for allowing us to speak on this very important topic. So Brunswick County has about 100,000 water connections, and that includes our wholesale customers that we serve. That means in our peak season, about now, we're serving about 300,000 people. We also operate the Lower Cape Fear Water and Sewer Authority that provides raw water to Pender County, Brunswick County, as well as Cape Fear Public Utility Authority, basically the city of Wilmington and surrounding areas. So in 2017, we learned about the PFAS issue. We also found out that our water treatment plants would not remove it. And so we started on a $170 million project to address the PFAS contamination. And so we're in construction with that project. Hopefully it will be completed next year. And utilities are passive receivers of PFAS. That means that we're not responsible for introducing PFAS into the environment. We don't use it in the production of our drinking water that hundreds of thousands of people rely on every day for their water. And there's really no other options in the region to supply that quantity of drinking water. Yet right now today, the cost burden lies solely on the utilities and their customers, not only to remove it from the drinking water, but also for disposal of it after it's removed. So I mentioned the impacts. We've got a $170 million project, and that's increased the rate currently from about $25 per month to $35 per month for our average user. That's about a 40% increase in utility bills. And our operational cost is going up about $2.9 million per year for perpetuity. We also expect additional future costs as regulations continue to evolve for both disposal and residuals management. And so in the regulatory world, there is a polluter pays principle. And so that is not currently being applied. We think it's important for that to be applied so that the cost burden is on the appropriate individuals. Thank you for your time.
Good afternoon, Chairman, members of the committee. My name is Wes Robinson. I'm Senior Director of State Affairs for the American Chemistry Council. ACC, if you're not familiar with us, represents companies in the business of chemistry, which in North Carolina is it represents about 20,000 employees at a value of $18 billion in product, making it the 7th largest chemistry producing state. I want to thank the bill sponsors for working to improve the legislation. The PCS is an improvement over past versions of the bill, but I did want to flag just a couple of concerns as the body considers next steps. Whereas the original version sought to regulate PFAS through the establishment of an arbitrary permissible concentration level, the current version ties the PCL to values recently proposed and published by the EPA. Now, to be clear, ACC is not opposed to the development of regulations like a drinking water standard, but they've got to be based on the best available in sound science. So with the value that the EPA recently published, there were a number of concerns with the values that they derived. Those concerns not just come from ACC and the National Association of Manufacturers, as was previously alluded to, but also water utilities, local governments, and the EPA's own Science Advisory Board. All have questions and concerns with the underlying science and the overall benefits analysis used to promulgate those standards. For instance, just last Friday, the American Water Works Association, and the Association of Metropolitan Water Agencies filed a petition to also review the rule that this legislation is based on. Additionally, I want to flag one other issue. I think there is a dangerous precedent that this bill may set by being retroactive to an arbitrary date in 2017. The legislation is retroactive to January 1st of that year. However, it's important to note that the EPA drinking water standards that this bill is based on were not published until April of this year. So although we have concerns with that underlying standard, it would reason that April of 2024 would be a more appropriate effective date. Members, thank you very much. Appreciate your time.
Please state your name and who you're with, please.
Thanks. I have a bad habit of just writing down my initials. So it's Lou Ann Perryman. I represent the North Carolina Manufacturers Alliance. And thank you for the opportunity to speak on House Bill 684 and the PCS before you. So currently on process, I'm a little concerned because I'm not aware of any member in the manufacturing community having any input into this bill or into the PCS. And on section, part 1, page 1, line 28, it seems the Secretary sees us have full authority without any legislative oversight. However, I do note that there are reports that are to be made at the end of the bill, and especially on the abatement piece, it's after the fact that that decision's been made. Also on part 1, page 2, line 9, joint and several liability is a chilling effect on recruitment of manufacturers going forward. And this is after this state has been named 2 years in a row for the #1 state to do business. Part 3, page 2, line 37, the effective date is very concerning. September 1, 2024, it applies the 2024 regulations to incidents that occurred as far back as 2017, irrespective of when an MCL was established by the EPA. For these reasons, the North Carolina Manufacturers Alliance respectfully opposes House Bill 864 and the PCS put forward today. I would like to point out that there are some good pieces in this bill, and we thank you for that. But as a whole, we'd have to oppose the bill and the PCS. So thank you so much for your time, and thank you for having the opportunity to speak.
Thank you very much for those comments. Jeff Fritz.
Chairman Gillespie, Chairman Eiler, members of the committee, my name is Jeff Fritz. I'm with the Chemours Company. I'd like to speak plainly today. As Representative Davis pointed out, this bill really targets my company and the 560 colleagues of mine who work at the Fayetteville Works plant in Fayetteville. The title and the definitions in the bill make that clear. And so I'd like to share a few facts that I think may be relevant to your consideration of this. We agree with the representative from CFPUA that citizens absolutely deserve clean and safe drinking water. And that's why in 2017, when this issue first arose in the media, Chemours made the voluntary decision to cease all water emissions from our site to the Cape Fear River. Cut it off 100%. Now, I must tell you that that only reduced the PFAS emissions to the river from our site as a whole by 97%, because there was still some historic groundwater impact. So Chemours built a 1 mile long, 7-story deep underground wall to capture all of those groundwater emissions, process them before any water went to the Cape Fear River. And that processing is operating at 99.95% efficiency. As was mentioned, we also discovered that there were air emissions of PFAS getting into the environment. And so Chemours built a state-of-the-art, never before done in the world, thermal oxidizer system that captures our air emissions and eliminates 99.999% of the PFAS in those air emissions. And we worked with DEQ to continue to address the historic issues. Given those actions, we respectfully ask that this bill not proceed.
Thank you. Kurt Osteen? You have 2 minutes, sir.
Thank you, Chairman. Thank you, committee. My name is Kirk Osteen. I'm with the North Carolina Chamber of Commerce. We have many members that feel strongly about this bill. Since we've just received it last night, we're still reviewing it. We're still hearing back from our legal folks and subject matter experts. We still have concerns with the PCS, such as the certainty it creates in our regulatory process and the potential harm that will be done to our legal climate. We look forward to working with Representative Davis and others on this bill and on this matter in the future. So I thank you.
Thank you. Representative Wheatley, you asked for the final word.
Thank you, Mr. Chairman. I'm just continuing to not understand why we have not had a better solution, especially for my community, where all our wells in one community, not all of them, but many, are contaminated with PFAS. And where we still have 2 schools that were contaminated, that have not had running water from the Public Works run to them, although we have continued from the state to try to help get funding for that. None of us want our citizens to be drinking contaminated water, but there are those that have wells in my community that are still continually having their wells tested and finding out that they have large amounts of PFAS in it. Even though this bill doesn't solve 100% of everything that we'd like to see, it may be just venue that we can continue to work on this problem to where all of us see our entire state drinking clean water and water that's not been contaminated, whether in the past or if it comes in the future. We want to be on top of that. The federal government did set out new guidelines, as you all are aware. For us in Cumberland County with our Public Works Commission, that is looking at being able to meet those standards at $100 million. And guess what? All the costs will be passed to the ratepayers, all of it. And all the costs so far, the ratepayers have had to pay for. So I am going to support this bill. Again, I hope that we can continue to look what we can do in partnership with those that we have worked with in Cumberland with Kim Morris, with our Public Works, and make sure that our children and our families are getting clean water. Thank you, Mr. Chairman.
Thank you, Representative Wheatley. Representative Davis?
Thank you. Just 2 quick points, if I may, in response to some comments that were made during the public. Number one, the enforcement has been delegated by the United States EPA to DEQ. That's who's responsible. And it tasks the Secretary of DEQ with enforcing drinking water rules to regulate public water systems. That's why DEQ is the person to make that determination. Also, I will say I appreciate what Camorris has done. This bill doesn't mention Camorris. This bill is targeted at anyone in this state that makes this stuff from scratch. Camorra happens to do that. But I will say, they knew very well what they were doing, and they didn't do any of these remediation efforts until they got caught in 2017. And that's why you have that date in the bill. So once again, I would ask you to please support the bill and give it a favor report so it can move forward. Thank you.
Thank you, Representative Davis. Any other comments from committee members? If not, I'd open the floor for a motion.
I'll make a motion. Oh, no, you make a motion, please.
Well, I'm on the bill.
Oh, okay. May I make a motion for the payroll report for the committee, substitute unfavorable from the original, and is it going to rules? Appropriations.
heard the motion, move that PCS House Bill 864 be given a favorable report, unfavorable original bill with re-referral to House Appropriations. All in favor say aye. Aye. Opposed? Appears the ayes have it. The ayes do have it. Meeting adjourned.